was not presented also. By the way, also we would like to mention that the letter of credit itself doesn't have any stamps of our bank, is not signed by anyone, and therefore is not authenticated. And it is not issued with the requirements of the SWIFT recommendation, SWIFT standard number 730. We are the bankers, we know how letters of credit look like. Therefore, we would like to conclude that all the claim, we would like to conclude that all the claims of the claimant should be rejected. We ask tribunal to extend the arbitration clause, not to extend the arbitration clause, to reject all the requirements that doesn't have money evaluation according to the Article 4 of the ICC rules, because the claimant asks to fulfill all legal costs, to award all legal costs, and others, but doesn't provide us with monetary evaluation. I will close my submission.
Thank you.
Thank you very much.
Yes, please. The first question for you, Counsel, is about the authentication of SWIFT. I'm confused, really, because in my understanding, the letter of credit was issued by the bank.
Yes, it was.
And now the bank in the proceedings is telling the tribunal that the letter of credit issued by this bank is not authenticated because the SWIFT was not used.
But it doesn't have our signatures, it doesn't have our stamps of the bank. We don't know where the claimant
So you dispute this
took
letter
this
of credit?
letter of credit.
At the end of the proceedings, you would like to dispute?
No, we just say that the letter of credit is not a proper evidence.
But you base your position on the list of the documents stated in the letter of credit.
Yes, well, we do not judge the documents. We just say that.
So what is the force of the letter of credit for the respondent? The legal force? How you consider the legal force in the letter of credit for your party?
Well, we consider that it's not a proper evidence.
Are you saying that it's not an authentic document?
Yes.
Okay.
And also just a follow-up question on that. What's the relevance of the shipbuilding contract not being notarized?
The letter of, as stated in UCP 600 Article 4, it's an independent agreement, and therefore we need to all the documents listed in the letter of credit should be presented as they require. So if there is no notarized copy, we cannot take just a copy.
Just a simple copy.
Yes.
For example, we can see here that there is a requirement in the letter of credit, and because you have an obligation to be in compliance with the letter of credit, we need to take into account that the document that is duly formalized. And there is a requirement that the copy of the contract should be notarized, but there is no sign that the present copy of the contract was notarized. There is no sign.
Where is that requirement that it be notarized?
What?
Where is the requirement?
Where is the requirement?
It is in the letter of credit.
In the letter of credit, page 21. I'm sorry, 20.
20.
Paragraph 1.
And also one small question about the witness statement. The claimant has voiced its argument about the witness statement providing the confirmation of signing the grant of acceptance. So, what is the respondent's position on this issue?
We believe that the evidence is not clear enough that the evidence provided by the claimant is not clear enough that it can prove the authentication and proper presentation of the act of acceptance.
Okay, thank you.
I add one point. Also, for example, there is no evidence in the case material that this person who is signed this document was an authorized person. Of course, if, for example, we have some document, for example, I don't know, attorney of this person, or for example, we have some letter from Ivan Abazic that he delegates his right to sign this contract to this Mr. Zhivzovsky. Yes. Arizovsky, yes. Okay. So we don't see this evidence, and we can't just make our payment on the some evidence the evidence presented by the client, because we need to have the documentation. We need to have the documents properly formalized, but we can't make the payment just living by this judgment.
Thank you.
Could you just please help me? Could you direct me where it is in your submissions that the letter of credit is not an authentic document?
Where in our submissions?
Yes. In your written submissions.
In our written submissions. Paragraph 70.
Which?
I mean, that's paragraph 70. Moreover, the letter of credit submitted by the claimant is not signed.
Paragraph 70 of which is this in your response to the?
This is
Yes. That's a request.
Oh, okay, I see. Okay.
I can
Paragraph
show you
70.
just a second.
We
This one, no.
Okay. All right. Thank you very much. For the reference.
Thank you. There are no more questions. The claimant for the rebuttal.
Members of the tribunal, letters of credit are used to provide certainty of payment. This certainty is maintained by the presentation of documents which are then evaluated on their face. The letter of credit was issued and authenticated using the unique banking signatures. The confirmation of this appears on page 20 of the record. Here, the seller evaluated the presentation on its face and was planning to honor. It did not, as respondent claimed, approach the buyer for waiver of discrepancies because it had not identified any discrepancies within the presentation. It then denied payment after a request to do so from the buyer, who was given an opportunity to give input on the presentation. The bank did not suspect fraud when it wrote the buyer, and buyer did not notify bank of fraud after the ceremony or before the presentation was made. Finally, the notice given to the seller did not include the objection to the contract in the presentation or the status of the documents at the time of its determination. So the respondent cannot maintain its objections to the presentation before this tribunal to evade payment. Accordingly, as the seller has met its obligations under the letter of credit and the contract, and the respondent has violated its obligations as a bank under the UCP 600 and under the specific letter of credit in particular, the tribunal should not uphold the bank's rejection and grant the seller the requested relief. Thank you.
Thank you. For the respondent, please. Rebuttal.
Yes. We would like to point out that the claimant didn't prove that we didn't approach for the buyer for the discrepancies, but we did. We wrote him a letter asking to confirm the payment. We made an additional work for which we didn't receive payment. If we consider the presentation improper, we could just refuse right away. But we were trying to help our claimants, and they should be thankful for us, and not blame us for approaching buyer. That's my point of view. Secondly, the presentation wasn't improper, and I showed you not only on the safety certificate and the act, but on the other documents, what we were unable to fulfill payment on the 10th of March. And now we simply cannot grant $11 million because the term of the letter of credit expired. And
Thank you. Before closing today's hearing, I will kindly invite you to state if you think you have benefited from a fair hearing. So, for the claimant,
Yes, I would think we benefited fair hearing.
for the respondent.
yes.
If there are no other further questions, the hearing is closed. Thank you.
Thank you very much.
Thank you.
Well done, people.
Thank you so much. Would you like us to step out?
But-
Can we ask you to leave everyone?
Can we leave everything?
Yes, please leave the room.